Dad's farm access road, locked by a fresh chain, was the only recorded route, and an HOA crest stared from a sign beside the clubhouse bulletin board as the padlock clicked in the heat. Marlene Sutter, the HOA president, served me the restriction with a calm smile and said the board approved it, calling the road HOA-controlled access, while neighbors slowed to watch. In my hand, a certified envelope held a notice of easement revocation, red-stamped stiff and heavy as a warning. "You don't get my road." Finally, someone fought back.
The HOA said it controlled the access road, but the county record still listed it as a public right-of-way. When paper and process don't match their chain, the system forces a check.
Certified mail. Beep at the post office counter. The sound cut through the low hum of ceiling fans and murmured small talk. The clerk slid a thick envelope across the worn laminate toward me. "Sign here." I signed. The return address read Cypress Ridge Homeowners Association. Stamped in red across the top, received HOA board action. The ink looked fresh, deliberate. Outside, the Florida heat wrapped around me like a damp blanket. I didn't open the envelope until I was sitting at my dad's kitchen table. The old oak surface still carried knife marks from when I was a kid. Above it, pinned to the cork bulletin board, was a copy of the farm deed Roy Hartman, sole owner. Dad watched me carefully. "Well," he asked. I slid a finger under the flap and pulled out the document. Several pages. Official letterhead. Bold heading. Notice of easement revocation. I read it once silently, then out loud. The HOA board has voted to revoke prior access allowances across the internal roadway adjacent to Cypress Ridge properties. Dad leaned forward. "Can they do that not without county approval and a filed amendment?" I said. "And even then, not retroactively." He frowned. "It says revoked. It says a lot of things." I flipped to the final page. No county filing number. No reference to a recorded amendment. Just a typed signature block and a date from 3 days ago. A knock sounded at the back door. Walter Green stepped in without waiting. He'd lived down the road longer than I'd been practicing law. Before retirement, he'd been a county surveyor. "Heard about the chain," he said. I handed him the notice. He adjusted his glasses and scanned the first paragraph. "They're calling it an internal roadway." "It's recorded public access," I said. "It was," he replied. "Still is, unless something's changed. That's what I'm checking." I tapped the speaker icon on my phone and dialed the county clerk's office. After 2 rings, a woman answered. "County records. This is Caleb Hartman. I'm calling regarding Parcel 14B access road designation recorded in 2020. "One moment." Dad sat very still. Walter leaned against the counter. A keyboard clicked faintly through the speaker. "Yes, sir," the clerk said. "That roadway is designated public right-of-way. Has any amendment been filed revoking or altering that designation?" Another pause. More typing. "No, sir. No amendment has been filed." "Thank you." I ended the call. Dad let out a slow breath. "So this notice has no county backing," I finished. Walter tapped the page. "They'd need a filing number. There isn't one." My phone buzzed again. A voicemail notification from Dawson Feed and Supply. I played it. "Mr. Hartman, this is Rick. We were advised not to use HOA-controlled access for delivery. Please clarify before we dispatch trucks." Dad rubbed his forehead. "They're spreading it." "They're applying pressure," I said. I flipped back to the first page and read the language again, slower this time. The wording was polished, careful, built to sound official, without citing authority. "Easement revoked," I repeated quietly. Walter shook his head. "You can't revoke a recorded public right-of-way with a board vote. That's what they're trying to suggest." Dad pointed to the bulletin board. "My name's on that deed. I've paid taxes on that land 40 years. "I know." He looked smaller in that kitchen than I remembered. The stroke had taken some of his balance, not his pride. "How long until harvest?" he asked. 6 days. And if trucks can't come through, we lose the contract." He stared at the document in my hand, as if it might rewrite itself. I grabbed a pen from the drawer and circled the word revocation. Then I circled the blank space beneath the signature where a filing reference should have been. "There's no county seal," I said. "No recording number." Walter nodded once. "It's HOA action, not county action." Dad looked between us. "So what does that mean?" "It means," I said carefully, "this isn't confusion." The ceiling fan creaked above us. "They know the road is public," I continued. "They know no amendment has been filed." Dad swallowed. "Then what is it?" I set the notice flat on the table. "This is the HOA blocking access without authority." Outside, a truck engine passed slowly along the main road, but didn't turn in. 6 days. The clock wasn't loud, but it was moving. Walter folded the notice and handed it back to me. "If they're willing to put this in writing," he said, "they think you won't push back." I looked at the red received stamp again. "They're wrong," I said. The chain wasn't old. That was the first thing I noticed when I pulled up to the farm entrance. Fresh zinc shine, no rust, no slack. It sat tight across the dirt road like it had been measured, like someone had practiced. A white sign had been planted beside it, squared to the road, with the kind of precision you only get from people who like control. HOA controlled access. No commercial vehicles. Trespassers will be towed. Below the block letters sat a small crest, the cypress ridge, oak, and laurel emblem printed in glossy green like a promise that this was official. Dad stood in the shade of the truck door, one hand gripping the top edge like it was a rail. He hadn't even tried to walk up to the chain. Pride kept him upright. Pain kept him still. "They really did it," he said. "They really did," I answered. Across the ditch, 2 residents slowed their golf cart down to a crawl, not stopping, just watching, as if they'd been waiting for a show to start. I stepped closer and knelt near the padlock. The metal was hot from the sun. New key scratches marked the cylinder recent use. I took out my phone and started filming without saying a word. I framed the sign, the chain, the surrounding posts. Then I angled down to the dirt itself. Because the dirt told the truth. Truck tracks cut into it, old, deep ruts that ran straight through the gate and past the clubhouse boundary. Those tracks didn't belong to an HOA. They belonged to 40 years of harvest seasons, feed deliveries, fertilizer loads, and Dad's own equipment. This road had been used like a road for so long, the earth remembered. Behind me, Dad's voice softened. "Caleb, don't do anything that gets you arrested." "I'm not touching it," I said. "I'm documenting it." A car door clicked shut. Footsteps on gravel, slow, sure not rushed. I turned. Marlene Sutter walked toward us from the clubhouse side like she owned the air around her. Navy blouse, pearl studs, clipboard held against her ribs like a shield. She didn't bring a deputy or security. She brought confidence. Behind her, the clubhouse bulletin board sat in full view: pool rules, lawn schedule, a flyer about community harmony. That same HOA crest stared from the corner of every sheet like a signature. Marlene stopped a few feet from the chain, careful not to cross an invisible line. "Mr. Hartman," she said to my father first, voice smooth as a practiced announcement. "I hope you're feeling well." Dad didn't answer. She shifted her attention to me. The smile she gave wasn't friendly. It was administrative. "You received the notice," she said. "I read it," I replied. She nodded once as if that completed something. "Then you understand the board's position. This access has become an HOA concern." I tilted my head. "A concern doesn't create ownership." Marlene didn't blink. "It runs adjacent to association property. We maintain the area. We have authority to control access that impacts the community." "That chain doesn't control impact," I said. "It controls my father's farm." Her smile held. "But the corners tighten the way they do when someone's patience is being measured." "This isn't personal," she said, and it landed like a lie that had been said so many times, it felt true to the person saying it. "Commercial vehicles increase noise dust and liability. Residents have complained." A golf cart paused across the road now, not subtle anymore. The driver pretended to check his phone while his passenger stared openly. Dad finally spoke, voice rough from disuse. "That's my only road." Marlene's eyes flicked to him for a moment. Not sympathy calculation. "The board voted," she said. "The restriction is approved." I let the silence sit long enough for the watchers to feel it. Then I held up the certified envelope, still stiff, still sealed at the edges, where I'd refolded it after reading. The red stamp looked louder out here in the sun. "You want this to look like county action," I said. "But it's not." Marlene's smile didn't move. "It is HOA action." I nodded slowly. "Exactly." Her eyes narrowed slightly, as if she could sense where I was going, but didn't want to give me the satisfaction of confirming it. I took one step to the side and pointed my phone toward the sign, then the chain again. "Say it again," I said, voice calm, "for the record." Marlene held my gaze. She didn't like being recorded, but she liked being challenged even less. "This is HOA-controlled access," she repeated the words, enunciated like policy. "No commercial vehicles." The padlock clicked as the chain settled in the heat metal, shifting against metal, like punctuation. Dad's knuckles whitened on the truck door. A woman across the ditch whispered something to her friend. The friend shook his head, still watching. Marlene continued, voice still gentle. "You don't need trucks coming through here. There are other options." "There aren't," Dad said quietly. Marlene's eyes returned to me. "You're an attorney, Mr. Hartman. You know escalation doesn't benefit anyone." I laughed once, soft, humorless. "Escalation," I said. "You put a chain on a farm road during harvest week." Her expression tightened by a fraction. Not anger. Annoyance that someone was naming the truth out loud. I leaned closer, not to the chain, but to the idea she was trying to sell the neighborhood. "You didn't call the county," I said. "You didn't file anything. You didn't seek an order. You just locked it." Marlene's voice remained even. "The board acted within its authority." "And if I cut it?" I asked. The watchers across the road stiffened. A breath held in a dozen throats. Marlene's eyes didn't leave mine. "Then you'd be trespassing on HOA-controlled property." There it was. Not a threat. A trap. I turned my phone slightly so it captured the sign, her face, and the chain in one frame. "Perfect," I said. Her brows pulled together. "Excuse me. You just claimed the road is HOA-controlled," I said. And you just claimed cutting the chain would be trespass. I lifted the certified notice again and tapped the bold heading with my finger. You're not confused, I continued. You're building a paper story for why you did this. Marlene's smile finally broke just a hairline crack. You're making assumptions, she said. No, I replied. I'm listening. Dad shifted beside me, swallowing hard, as if each word cost him something. Marlene, he said, and his voice surprised me, steady, older than pain. I've paid taxes on that land since before your clubhouse existed. Marlene's eyes softened for half a second, then hardened again. And now you have a community next door, she said. Communities have standards. Dad's jaw worked once. He didn't argue. He didn't beg. He just looked at the chain. I put my hand out, not touching him, not crowding him, just anchoring the moment. We're not cutting anything, I said quietly to him. Not today. Dad exhaled, relieved and furious at the same time. Marlene's shoulders loosened as if she'd just won something. And that told me everything. She didn't want a judge, she didn't want paperwork. She wanted a reaction she could weaponize. So I gave her the opposite. I stepped back, lifted my phone higher, and spoke clearly enough for the neighbors to hear. Today's date, I said into the camera. Farm Access Road, blocked by HOA chain and signage. HOA President. Marlene Sutter confirms restriction is board approved and claims HOA control over access. Marlene's face went still. I kept filming. And this is the only recorded route for harvest delivery, I added. Interference risks contract loss. Across the road, the golf cart driver finally looked away. Not bored, uncomfortable. Marlene's voice sharpened. You're threatening the association. I'm preserving evidence, I replied. She took a step closer, her clipboard tight against her body. The board will enforce. I met her gaze without blinking. Good, I said. Enforce it on camera. Her eyes flashed. Then the smile returned, forced, now brittle. You don't get my road, she said softly, as if she were talking to a child who didn't understand rules. Finally, someone fought back. For a second, nobody moved. Even the wind seemed to pause. Dad's hand trembled on the truck door, and I realized something cold and clean. She wasn't acting like someone who thought she might be wrong. She was acting like someone who thought we couldn't afford to prove her wrong. I stopped recording and slipped the phone back into my pocket. Then I took the certified notice, turned it over, and traced the blank space where a filing number should have been. I looked at Dad. 6 days, I said. He nodded once. I looked back at Marlene. Now I said we do this the legal way. Marlene's smile held barely, but her eyes followed me as I walked back to the truck, already planning what to do next. Because chains were easy, records were heavier. An association's enforcement power is limited by the scope of authority granted in its recorded declaration, not by proximity to property it prefers to regulate. If a roadway serves privately owned agricultural land and predates the association's formation, the threshold inquiry is whether the governing covenants expressly grant control over that access corridor. Absent recorded language conveying ownership, easement rights, or regulatory control, unilateral restriction through signage or physical barriers risks exceeding delegated authority. Judges evaluating such a dispute would focus first on the document hierarchy: deed, recorded plats, easements, and the declaration of covenants. An HOA board vote does not elevate internal policy above recorded property interests. Where no filed amendment or supplemental declaration expands common area boundaries, Enforcement actions targeting adjacent private access can be characterized as ultra-vires. That classification matters because courts often assess whether the association acted within the four corners of its recorded powers before considering reasonableness. Risk exposure cuts both directions. If the association mischaracterizes private property as HOA controlled, it faces potential claims for trespass, to land interference with business expectancy, or wrongful obstruction of an easement. Conversely, if the landowner removes a barrier without confirming record title or easement scope, he may expose himself to trespass or damage allegations if the HOA can demonstrate a valid servitude interest. The burden of proof typically rests on the party asserting control inconsistent with record title. However, evidentiary weight shifts if historical use suggests a prescriptive easement or implied access right benefiting either side. A material variable that could alter the analysis is whether any recorded reciprocal easement agreement exists between the farm and the subdivision, even if informally referenced in marketing materials or development approvals. County permitting documents or subdivision plats sometimes embed access reservations that do not appear in later correspondence, but remain legally operative. Practical legal takeaway. Enforcement authority must be traceable to recorded instruments. Before restricting access, associations should confirm the chain of title and any easement grants. Before challenging a restriction, landowners should obtain certified copies of deeds plats and prior access agreements to clarify the control boundary that a court will ultimately apply. Walter unrolled the county plat map across my dad's scarred tool bench. The paper snapped at the corners before settling flat beneath a rusted wrench and a box of fence staples. Sunlight slipped through the open garage door and stretched across the faded grid lines. "There," Walter said, pressing a finger to the center of the page. A thin blue line ran along the eastern edge of the subdivision. Printed beside it in small block letters, "Public right-of-way." I leaned closer. "That's the access road," I said. "That's the access road," he confirmed. "Recorded in 2020 when the county approved the expansion. And never amended. Not unless something's been filed since." I checked my phone again, though I already knew the answer from the clerk. Nothing new had been recorded. My goal was simple: prove the HOA never owned the road they chained. Prove it in a way that couldn't be brushed aside as opinion. Walter tapped the paper again. "Let's match it to the ground." We carried the map out to the farm entrance. The chain still stretched tight across the dirt, the first sign glaring white in the sun. Two neighbors stood on the far shoulder pretending to check their mail. They weren't subtle. Nobody wanted to be involved, but nobody wanted to miss it either. Walter walked along the edge of the ditch, counting steps under his breath. He stopped near a patch of scrub and pushed a metal probe into the soil. "Here." I knelt beside him. After a few inches, the probe struck something solid. Walter scraped away dirt until the top of an old survey marker emerged capped in plastic. He smiled faintly. "Original boundary." I grabbed a fresh wooden stake from the truck bed and drove it into the dirt next to the marker. The hammer struck clean. Thud. Again. Thud. The sound carried farther than I expected. A white pickup rolled up slowly behind us. Board member number 2 stepped out. His name was Thomas, and he looked like he'd rather be anywhere else. "What are you doing?" he asked. "Verifying the record," I said. Walter held up the map. "This line is public right-of-way." Thomas glanced at the chain. "Marlene says the board acted to protect property values. Did the board vote to restrict recorded access? I asked. He hesitated. We voted to review traffic concerns. That's not what I asked. Thomas lowered his voice. We never voted to restrict recorded access. The two neighbors across the road leaned closer. Before I could respond, a second vehicle pulled in behind Thomas's truck. A maintenance worker stepped out carrying another sign. I watched as he drove a metal stake into the ground, 10 feet from the chain. He bolted on a new placard. No commercial vehicles. The message was louder than the first. Walter exhaled slowly. They're layering it. Thomas rubbed his neck. I didn't authorize that. But it's being done under the HOA name, I said. He didn't argue. I stepped back and framed the scene with my phone camera, the original survey marker, the fresh stake, the chain, the two signs. The blue line from the plat map matched the path of the dirt road exactly. I started recording. This line was filed with the county in 2020, I said into the camera. It designates this road as public right-of-way. There has been no amendment recorded. Walter stood beside me, nodding. The HOA doesn't have authority to reclassify a public road without county action, I continued. And no such action exists. Thomas shifted uneasily. You're escalating this. They escalated it when they blocked access. Behind us, one of the neighbors finally spoke up. Is it really public? Walter answered before I could. It's on record. The neighbor nodded slowly, absorbing that. I stopped recording and opened my laptop on the tailgate of my truck. Heat shimmered off the hood. What are you doing now? Thomas asked. Drafting a formal demand, I said. Requesting an emergency public hearing. Public, yes. On record. Thomas glanced toward the subdivision entrance as if expecting Marlene's SUV to appear at any second. You could just wait, he said. For what? Another sign. He didn't respond. I typed steadily, attaching the plat map copy and referencing the parcel number. The language was precise, direct, unemotional. Request for emergency public hearing regarding recorded public right-of-way and unlawful restriction of access. Walter read over my shoulder. Make sure you cite the recording number. I will. When I finished, I hit send to the HOA board distribution list and copied county records. The email left my outbox. Minutes later, my phone buzzed. From Marlene Sutter, subject re-emergency hearing request. I opened it. The HOA denies your request. No explanation, no citation, just denial. I looked up at the second sign, white letters bright against the clay. They're doubling down, Walter said quietly. I folded the plat map carefully and slid it back into its tube. They can deny a request, I said. They can't erase a record. The chain rattled lightly in the breeze, metal brushing metal. The road beyond it stayed still, waiting. So did I. 6 days until harvest delivery. 2 chains now blocked the only road. The second one had been threaded through the first overnight, doubling the steel, doubling the message. The padlocks hung side by side like punctuation. I stood at the gate with the harvest contract folded in my back pocket. I had read one line so many times it felt burned into my memory. Failure to deliver voids agreement. $82,000 balanced on a clause and a chain. Marlene arrived just after 8. This time she wasn't alone. One HOA board member stood a few steps behind her, arms crossed, expression tight. You received our denial, she said. I did. The HOA's position remains unchanged. You don't have authority to change it, I replied. She gestured toward the houses beyond the entrance. We're protecting property values. With what? A chain, with enforcement of our covenants. This road isn't governed by your covenants. She folded her hands in front of her. It runs adjacent to HOA property. It is recorded public right-of-way. That's your interpretation. I pulled my phone from my pocket and tapped the county clerk's number again. Marlene's mouth tightened. We've been through this. Yes, I said. We have. The clerk answered. County records. This is Caleb Hartman again. Parcel 14B access road designation. Has any amendment been filed since yesterday I switched to speaker? Keyboard clicks filtered through. No, sir, the clerk said. There is no amendment on record. A few neighbors had gathered along the shoulder. I heard a low murmur ripple through them. Marlene stared at the ground, then back at me. You're misrepresenting the situation. Am I? You're creating conflict where there doesn't need to be any. Two chains say otherwise. Dad's truck rolled up behind me, engine idling. He stepped out slowly, leaning slightly on the door before closing it. Morning, he said quietly. Marlene nodded at him, but didn't smile. You going to open it? Dad asked me. Not without a court order. He looked at the doubled chain and then at Marlene. That's my only road. The HOA is reviewing access concerns, she said. Review it after harvest, he replied. She didn't respond. The board member behind her shifted his weight. Maybe we should take this back to the board. We did, Marlene said sharply. I stepped closer, careful not to touch the chain. Produce the filed amendment, I said. There isn't one yet. Then you have no authority. The HOA protects property values, not by blocking a recorded public road. Silence settled between us. Dad pulled the contract from my back pocket and held it up. 6 days, he said. After that, it's gone. Marlene glanced at the paper but said nothing. I turned back to my truck, opened the tailgate, and set my laptop down. The screen glared in the sun until I angled it just right. What are you doing? She asked. Filing. For what temporary restraining order? That's unnecessary. It's required. The keys clicked under my fingers. I attached the plat map, the deed copy, the clerk's confirmation, and the vendor voicemail transcript. Each file name lined up neatly in the upload window. Behind me, someone whispered, "He's taking it to court." I finished drafting the motion and hovered over the submit button. This doesn't have to go this far, Marlene said. It already has. I clicked submit. For a moment, nothing happened. The page refreshed slowly. A small, spinning circle turned in the corner of the screen. Then it appeared. Filed. Case number assigned. Dad let out a breath he'd been holding. The neighbors' murmurs shifted in tone. Not gossip now. Anticipation. Marlene's composure tightened around the edges. You're escalating this, she said quietly. I closed the laptop and looked at her. No, I said. I'm putting it on record. She held my gaze for a long second. See you at the hearing, I added. The wind tugged at the second sign. No commercial vehicles rattled faintly against its stake. Marlene stepped back toward her car. You're escalating this, she repeated softer now. I glanced at the chains one more time, metal layered over metal, authority layered over assumption. 6 days, Dad said beside me. Not anymore, I replied. The road beyond the gate lay silent, waiting for the court to speak. County hearing chamber. Coffee. Paper. Silence. The room felt smaller than it had any right to be. Folding chairs lined the back wall. A coffee urn hissed faintly near a stack of styrofoam cups. Files sat in neat piles on the long table at the front. Marlene sat to my left spine, straight hands folded over a leather folder stamped with the Cypress Ridge HOA seal. She wore the same controlled expression she'd worn at the gate, as if this were just another board meeting. Walter leaned toward me and spoke low enough that only I could hear. "Let the record speak." I nodded. The hearing officer entered and took his seat. A county clerk settled beside him, fingers poised over a keyboard. "This matter concerns Parcel 14B. The officer began, and a motion for temporary restraining order regarding access to a recorded roadway. He looked at me. "Mr. Hartman," I stood. "The HOA has blocked a recorded public right-of-way," I said. "We are asking the court to restore access pending full review." Marlene didn't look at me. The officer gestured. "Present your evidence." I stepped forward and handed the clerk a copy of the 2020 plat map. The paper felt heavier in that room. "This map was recorded with the county when Cypress Ridge expanded," I said. "The blue line marks the public right-of-way providing access to my father's farm." The clerk examined the document and nodded. "Recording number 2020-4417. Yes." Marlene's attorney cleared his throat. "The HOA has traffic concerns. Traffic concerns do not revoke recorded access," I replied. The officer raised a hand slightly. "Proceed." I continued. "We contacted county records. No amendment has been filed altering this designation." The clerk tapped her keyboard. "Can you confirm?" the officer asked. She looked up. "No amendment has been filed regarding that roadway." A murmur moved through the chairs behind us. I recognized a few neighbors from the entrance. They weren't whispering now. They were listening. Marlene leaned toward her attorney and whispered something, then straightened. "The HOA acted within its discretionary authority to protect property values," she said. "Authority over what?" I asked. "A road it does not own." The officer turned to her. "Does the HOA possess documentation transferring ownership of the roadway?" "Our board minutes reflect a vote to restrict access," she answered. "That is not what I asked." Her jaw tightened, but she didn't speak. I placed the vendor affidavit on the table next. "This is a statement from Dawson Feed and Supply," I said. "They were advised not to use HOA-controlled access." The officer skimmed it. "Signed and notarized?" "Yes." And the impact, I reached into my folder and unfolded the harvest contract. "Delivery window closes in 6 days," I said. "Failure to deliver voids agreement." The officer looked at the contract, then at me. "And this access road is the only recorded route it is." He turned again to the clerk. "Confirm the designation." She typed for several seconds, then stopped. "The road remains public right-of-way," she said clearly. The words settled into the room like a weight dropping into place. Marlene shifted in her chair. "The HOA acted within discretion," she insisted. "The board believed it was within its rights to manage adjacent access." "Manage," I repeated. "Not reclassify." Her attorney spoke carefully. "There is ambiguity regarding maintenance responsibility." "Maintenance," I said, "is not ownership." The officer leaned back slightly, hands clasped. "Has the HOA filed any amendment with this court or with county records?" he asked. "No," Marlene said. "Has the county vacated or altered the right-of-way designation?" The clerk answered before anyone else could. "No, sir." Silence followed. I felt Walter's hand settle lightly on my shoulder. Steady. Present. The officer looked down at the motion in front of him. Based on the evidence presented, he said the roadway remains a recorded public right-of-way. The HOA has not filed an amendment nor demonstrated authority to restrict access. Marlene's composure flickered just slightly. We request temporary restraining order to restore access pending full hearing, I said. The officer nodded once. Motion granted. The words didn't echo, but they might as well have. For the duration of review, he continued, the HOA is restrained from obstructing or restricting access to the recorded public right-of-way. A soft exhale moved through the back row. Marlene sat very still. The officer added, "This order is effective immediately." The clerk typed rapidly. A printer behind the bench began to hum. Paper slid out. Official seal. Signature. The record spoke. I turned slightly and met Marlene's eyes. "We'll see," she said, her voice tight. The HOA acted within discretion. I didn't answer. The clerk handed me a stamped copy of the order. The seal caught the light just like the padlock had days earlier. Outside the chamber, the hallway felt warmer, louder. Neighbors stepped aside as we passed. Walter leaned close again. Temporary, he reminded me. But real. I nodded. Through the courthouse window, I could see the sun hanging high over the county parking lot. Somewhere beyond it, 2 chains still hung across my dad's road. For now, they hung against a court order. Behind us, Marlene's voice carried faintly as she spoke to her attorney. The HOA acted within discretion, she repeated, but the record disagreed. Discovery arrived in a compressed digital folder just before sunset. The notification blinked on my screen while the last light of the day slid through the blinds of my office. Outside traffic along Main Street hummed low and steady. Inside, the only sound was the soft whir of my desktop fan. I clicked the download link. The folder name was simple, HOA_response_discovery.zip. I extracted it and began opening files one by one: board minutes, maintenance invoices, internal memos. Then I saw an email chain labeled Road Access Discussion. I opened it. The subject line stopped me cold. If we pressure them, they'll sell. The timestamp was 3 days before the second chain went up. I read the first message carefully. From Marlene Sutter to HOA board members. Access to the Hartman parcel remains technically recorded public, but enforcement leverage exists. If we apply access pressure now, they may reconsider holding the parcel. Long-term, this protects community values. Technically, recorded public. Enforcement leverage. I leaned back slowly in my chair. Walter sat across from me, hat resting on his knee. "What did you find?" he asked. I turned the monitor toward him. He read in silence, lips moving slightly. "She knew," he said finally. "Yes." "She knew it was public." "Yes." Another email followed beneath it. Board member number 2, Thomas. "Do we have authority to restrict recorded access without county amendment?" Marlene's reply came 2 minutes later. "We can act under covenant enforcement and address amendment later if necessary. Address amendment later, not before." Later. I felt something shift in my chest. The earlier arguments about confusion or discretion evaporated in the glow of my monitor. This wasn't misunderstanding. It was intent. My phone rang. HOA Council. I answered. "Mr. Hartman," he said evenly, "you've received our discovery materials." "I have. You'll see that the board acted in good faith regarding property concerns." "Good faith?" I asked. "Your client acknowledged the road was recorded public. There were discussions about applying pressure." A pause. The language was informal. It was strategic. Another pause. The HOA was attempting to protect its interests by blocking the only recorded access to a farm during harvest week. Exhaled softly. The board believed it had discretion. Discretion doesn't override county record. Silence filled the line for several seconds. "You're planning to seek permanent relief," he said. "Yes. That's unnecessary. It's necessary to prevent this from happening again." "We disagree." "I'm sure you do." When the call ended, I printed the email thread and placed it beside the plat map and the TRO. Paper against paper. Record against record. Later that evening, I drove past the farm entrance. The chains were gone, removed after the temporary restraining order, but the signposts still stood empty and leaning slightly. Dad was in the barn when I arrived, checking the irrigation lines. "They took the chain down," he said, without looking up. "They had to." He wiped his hands on a rag. "Is it over? No." He studied my face. "What now?" They knew the road was public. He stopped moving. "Knew there are emails." I handed him the printed copy. He read slowly, lips tightening at each line. "Pressure," he repeated. "They wanted us to sell. That's what it says." He folded the paper carefully and set it on the workbench. "I worked that land 40 years, he said. "Now they think they can squeeze it." I didn't answer. The statement didn't need commentary. The next morning, I requested a meeting with Thomas. He met me outside the clubhouse, hands shoved deep into his pockets. "You've seen the emails," I said. He nodded. "We didn't vote to restrict recorded access," he said quietly. "We voted to review traffic patterns. And yet 2 chains went up." He looked at the parking lot asphalt instead of at me. "She said it was temporary leverage." "Against what? The parcel?" "Did you know the road was public?" "Yes." "And you allowed the restriction." "I didn't authorize it," he said. "But I didn't stop it either." I let the silence sit between us. Residents were starting to gather near the bulletin board. Word had spread quickly after the TRO. Thomas I said, "This isn't about traffic." He glanced at me. "It's about limits." He didn't disagree. By mid-afternoon, I finalized the motion for permanent injunction. This time, the language was sharper. The HOA knowingly obstructed a recorded public right-of-way. The obstruction caused financial risk and delivery interference. Internal communications confirm awareness of public designation. I attached the email chain as Exhibit C. When I uploaded the motion to the county portal, the system paused briefly before refreshing. Filed. Case updated. I forwarded the confirmation to HOA counsel and to Marlene. Within 20 minutes, my phone buzzed. "Marlene," I answered. "You're mischaracterizing internal discussions," she said immediately. "I'm quoting them. The board was brainstorming. You wrote that the road was recorded public. That doesn't eliminate our discretion. It eliminates your authority to block it." She inhaled sharply. "You're escalating this," she said. "You escalated it when you applied leverage. You could have handled this quietly, with a private negotiation over a public road. You're making this bigger than it needs to be." "No," I said evenly. "I'm making it permanent." There was a long pause on the line. "We'll see you at the hearing," she said. "Yes," I replied. "We will." That evening, the community bulletin board carried more than landscaping notices. Someone had pinned a copy of the TRO. Beside it, another resident had taped a printed excerpt from the email thread. "If we apply access pressure now..." People stood in small clusters reading. I thought it was a mistake, one woman said. Doesn't look like one, another answered. Walter joined me near the edge of the lot. You see that? He asked. I nodded. Support, he said. It's not loud, I replied. It doesn't have to be. My phone vibrated again. County scheduling notice. I opened it. Permanent injunction hearing. Next Thursday, 9 a.m., 6 days. The same window that had once threatened harvest. Now it marked something else. I looked across the lot at Marlene standing near her SUV. She wasn't speaking. She was watching. The pressure she'd planned had shifted. It wasn't squeezing us anymore. It was narrowing around her. Next Thursday, the record would speak again. Dad sat behind me in the courtroom, his hat turning slowly between his hands. He didn't fidget. He just held it there, thumb rubbing the brim, as if it were a worrystone. The wooden benches creaked as residents settled in. The room smelled faintly of coffee and old paper. At the front, the judge flipped through the stack of filings. My motion, the plat map, the email thread, the vendor affidavit, each page turned with a soft, deliberate sound. Marlene sat at the opposite table with HOA counsel. She wore navy again, posture, rigid chin lifted just slightly higher than usual. She didn't look at Dad. She didn't look at me. The clerk called the case number. We stood. Mr. Hartman, the judge, said, adjusting his glasses. You are seeking permanent injunctive relief regarding obstruction of a recorded public right-of-way. Yes, Your Honor. And you allege the HOA knowingly blocked access without authority. Yes, Your Honor. He glanced toward Marlene's table. HOA counsel rose. The board acted within discretion to address traffic and property concerns. The judge held up a hand. Discretion over what exactly? The adjacent roadway. The roadway recorded as public in 2020, the judge asked. A pause. The board believed it could regulate usage. Usage, the judge repeated, scanning the email exhibits. Or leverage. The word hung in the air. Marlene's jaw tightened. The judge continued reading silently for several moments. The only sound was the rustle of paper and the faint hum of the overhead lights. Dad shifted slightly behind me. I kept my eyes forward. Mr. Hartman, the judge, said the county clerk previously confirmed no amendment was filed altering the roadway's designation. That is correct. And discovery materials indicate the HOA acknowledged the public status of the road. Yes. The judge turned another page. This email states, quote, access to the Hartman parcel remains technically recorded public. He looked up at Marlene. Is that accurate? Her counsel cleared his throat. The language was informal, internal discussion. That was not my question, the judge replied. Marlene finally spoke. Yes, she said. It was recorded public. And yet the HOA installed chains restricting access. Yes. And posted signage prohibiting commercial vehicles. Yes. The judge leaned back slightly. So the board knowingly obstructed a recorded public right-of-way without filing amendment or seeking county approval. Silence. Counsel attempted to respond. The board was acting in what it believed to be the community's best interest. The community's best interest does not supersede county record, the judge said evenly. A murmur moved through the back benches. Dad's hat stopped turning. The judge set the papers down in a neat stack. This court finds that the HOA exceeded its authority and unlawfully blocked recorded public access. The words were steady, measured. Marlene's shoulders stiffened. The temporary restraining order will be converted to a permanent injunction, the judge continued. The HOA is permanently enjoined from obstructing or restricting the recorded public right-of-way identified in Parcel 14B. Dad exhaled behind me, not loudly, just enough. The judge wasn't finished. The court also notes internal communications indicating awareness of the roadway's designation prior to obstruction. A sanctions review will be scheduled. That landed harder than the injunction. HOA counsel scribbled something quickly. Marlene stared straight ahead. Order to be entered immediately, the judge concluded. Effective upon filing. The gavel tapped once. Not dramatic, just final. Outside the courtroom, the hallway felt brighter than it had earlier that week. Residents who had attended the hearing gathered in small clusters. Walter stepped forward and gripped my shoulder. That's permanent, he said. Yes. Dad came up beside me, hat now tucked under his arm. You did it, he said quietly. We did it. Across the hall, Marlene spoke in low tones with her attorney. Her composure was intact, but the edges were gone. The calculation had been replaced by something heavier. By noon, we were back at the farm entrance. A county deputy stood nearby as a formality, holding a copy of the signed order. The seal caught the sun the same way it had in the hearing chamber. The chains still hung across the road, though looser now, as if waiting. The deputy handed the document to Marlene. You're required to remove the obstruction immediately, he said. She read the first page without expression. Dad stood a few feet behind me, silent. For a moment, no one moved. Then Marlene nodded once to the maintenance worker who had installed the second sign days earlier. He stepped forward with bolt cutters. The metal jaws closed around the first chain. A sharp snap cut through the heat. The chain sagged. The second followed. When the final link gave way, the metal fell to the dirt with a dull, heavy thud. Dust rose briefly, then settled. The road lay open. Not temporarily, not conditionally, open. A neighbor who had watched from across the ditch walked closer, hands in his pockets. He looked at the cleared path, then at me. Finally, someone fought back, he said. No applause, no cheers. Just a quiet acknowledgement. Dad stepped forward slowly and placed his boot on the dirt road beyond the gate. He didn't rush. He just stood there for a second, as if reacquainting himself with something that had always been his. I turned toward Marlene. This was never about traffic, I said. She didn't respond. The deputy folded the cut chain and set it aside. Sanctions hearing will be scheduled, he reminded her. She nodded faintly. The maintenance worker removed the signposts next, twisting them free from the clay. The ground bore the marks of where they'd stood, but nothing else. Walter joined us at the edge of the road. Record corrected, he said. Record protected, I answered. Dad looked down the length of the path leading toward the barn. Sunlight stretched across it without interruption. The harvest trucks would come tomorrow. Legally protected. Behind us, residents lingered only briefly before returning to their routines. The spectacle was over. The road remained. I picked up one of the cut chain segments and held it for a moment. Cold steel. Heavy. Once used as leverage, now useless. I dropped it beside the ditch. The dirt settled again. The only road to my dad's farm was open, and this time it was protected by more than memory. It was protected by the record. The first harvest truck rolled through at dusk. No chain, no sign. The tires pressed into the clay and left deep, certain tracks. Diesel rumbled low across the field, steady and familiar. Dust lifted behind the trailer and drifted golden in the fading light. Dad stood beside me at the edge of the road, hands resting on his hips. His name was still on the deed, pinned back in the kitchen. It had never moved. It had never needed to. The driver leaned out of his window and gave a short wave. "Road's clear," he called. "Clear," I answered. The truck moved past us and into the field metal bed, catching the last streaks of orange sky. For a moment, neither of us spoke. 6 days earlier, that same road had been silent. Now it carried weight again. Dad let out a slow breath. "Looks like it always should have." "It is," I said. The next Saturday, the smell of smoke and grilled corn drifted across the farm. A few neighbors had shown up with folding chairs and paper plates. Nothing formal. Just burgers, iced tea, and quiet conversation. Walter sat near the fence line, hat tipped back, watching the trucks move in and out without interruption. "You think they'll try again?" someone asked from behind the grill. "No," I said. "Why not?" "Because they can't." Earlier that week, the HOA board had held a special session under more scrutiny than it had ever known. Residents filled the clubhouse folding chairs. This time, no one pretended not to see what was happening. Thomas stood at the front with a printed draft in his hand. "We are proposing an amendment," he said, voice steadier than before. "No HOA officer may restrict recorded access without county approval." A murmur passed through the room. Marlene sat near the edge of the table, silent. Thomas continued, "Any future action affecting a recorded public right-of-way must be supported by a filed amendment and reviewed publicly." Hands rose. Questions were asked. No one mentioned leverage. When the vote was called, the result was clear. Amendment passed. Now at the Saturday BBQ, someone handed me a cold soda and nodded toward the clubhouse across the road. "You seen the board?" he asked. "I have." That morning I'd driven past and stopped long enough to step inside. The bulletin board carried 2 documents side by side. On the left, the signed permanent injunction seal, bright and official. On the right, the community amendment signed by the board, stamped and dated. "No HOA officer may restrict recorded access without county approval." I had stood there for a moment longer than necessary, reading the lines again. Not because I doubted them, because they mattered. Back at the farm, Dad eased himself into a folding chair and watched the sunset bleed across the field. 40 years, he said quietly. "I've never missed a harvest." "You didn't," I replied. He glanced at me. "You didn't have to fight like that." "Yes, I did." Walter raised his cup slightly from across the yard. "Limits," he said. "Limits," I agreed. As dusk settled, another truck rolled through the entrance. The headlights cut briefly across the trees before dipping down the path toward the barn. No chain rattled, no sign warned, just the soft hum of an engine and the click of gears shifting. Later that evening, after most of the neighbors had left, I walked alone toward the road. The automatic gate installed years ago for livestock control stood open. I pressed the remote in my hand out of habit. Click. The mechanism responded smoothly, not with force, but with function. The gate slid shut, then open again, when I pressed the button once more. No one stood guard. No one measured who passed through. The permanent injunction had been recorded with the county. Any attempt to reclassify the road would violate a court order. Any attempt to restrict access would trigger sanctions already pending review. The leverage had nowhere to attach. The pressure had nowhere to land. Dad joined me at the entrance, slower now, but steady. "Feels different," he said. "It is." He looked down the stretch of dirt that led from the road to the fields. Moonlight had begun to replace the last of the sun. "They blocked you," he said. They blocked us. He nodded once. I thought back to the first morning, the chain flashing in the heat, the sign declaring control, the quiet confidence in Marlene's voice. Control doesn't announce itself, it just blocks. But the record does something else. It answers. The HOA blocked me from my dad's farm, so I reclaimed the road, and the court left them no way in. Behind us, the gate clicked open once more for the final truck of the night. No chain, no sign. Just a road legally protected, running exactly where it always had.
Before reacting to the confrontation itself, it helps to step back and examine the structural boundaries that actually define what a board can and cannot do. HOA authority usually stop where the record starts. A board can manage common errors in for written covenant and flaws are not noticed and hearing procedures, but it cannot convert a record right away into HOA control. Accept by signal, a letter here, stamp, or a vote that never gets recorded. In practice, the limit is procedural. Written authority document scope and use process that matches the governing documents. A board vote can create a plea. A record document establish the boundaries that policy can cross. People forget how much HOA power is performance. The control, the logo, the effective immediately pricing, the cue trigger compliment before anyone asks the boring question. Where is it written and where is it recorded? If you follow along with the HOA dispute, you can almost predict the turn. Is readily the lowest person who wins is the cleanest paper trail. One small pound. If you want a practice approve, keep in internation claim, move every claim into right, because favorable clarification don't hold safe as a specific provision they are relying on, and ask for the recorded referring that supposedly change the status of the asset. When they report without citation, pressure that report as part of the timeline email, certified mail, photos, and poster notice, and that sort of any obstruction. Here's a broom part. Support approve it not through authority is just a session. Someone hope you treat like a structure, and I know it's a way. You want to be responsible. You want it handled quietly, but quiet doesn't protect your rights. Documentation does. What for their case is the same pivot every time. When a dispute is forced into record, the story stop being about who sound confident and start being about who can actually point to the sound. That's why keeping you tone steadily master, not because it's plotted, but because it keeps focus on process instead of a goal. After that, the outcome tends to become inevitable in a very unceasing way, not dramatic, just structural. When action are measured against variable sound rather than precision, the dispute resolvable and documentation instead are the manual.